Right this way.
I see. Okay, Mr. Mejorado, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 9th, 2025, at approximately 3:30 a.m., officers were dispatched in response to a motor vehicle that ran off the road. The officers respond to the defendant's motor vehicle, a Dodge Ram, in a grassy area adjacent to a service road on the East Freeway. Service road in Harris County, Texas. The officer observed the defendant and walked over to the defendant walked over and advised that he was leaving the parking lot and lost control of the motor vehicle when he drove through the puddle of water. The defendant's motor vehicle left the road and got stuck in the mud. The defendant stated his friends were there helping him pull the motor vehicle from the mud. The officer observed glassy eyes, slurred speech, and odor of alcoholic beverage. The defendant stated that he did not have anything to drink, and the officers relocated him to JPC to continue the investigation. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read, consented to brag, and the results were a .148 and a .143. It was identified by his Texas driver's license.
Yes, sir, I'm going to find that there's sufficient probable cause to go.
Quick pause. This is the moment the judge confirms probable cause. That's the legal green light that allows the case to move forward, even before a trial. Notice how he checks for prior DWIs? This determines how tough the bond conditions might get. What would you do if a judge laid out rules this strict?
Forward with the case. You look to see any prior DWIs, and if he has.
There's no prior DWIs, and his license is
Okay. Mr. Mejorado, I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Likewise, if I find that you're driving without insurance, your bond will be revoked. You will go into custody. You understand?
Sir.
Do you have the ability to hire a lawyer?
No.
I'll have you fill out an application. I'll look to see whether you qualify. Deputy Miranda's going to give you an application. We'll have you fill it out. I'll have you sign a reset with Victoria. You'll get with Felicia for your bond conditions, then I'll take a look at it shortly. Please. You ready? Hey, good morning. You want to do the arraignment first or which one? Okay. Come up, man, please. So she has a co-defendant. Do you guys represent the co-defendant? Do you know?
No.
No?
I believe the defendant also has a felony because he had prior thefts on it,
Really?
but she is a first-time offender. And her, yeah. And her involvement in it is not as much as the co-defendant's.
Ms. Ayala, you're charged with, you speak English, ma'am?
Yes, sir.
Okay, Ms. Ayala, you're charged with theft. Shh. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 9th, 2025, at approximately 5:43 p.m., an officer was dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized Defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as Defendant Ayala, and Defendant Sauceda entered the store and went to a cell phone station. Defendant Ayala distracted the cell phone employee while Defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, Defendant Ayala received a text message from Defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. Do you understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it.
Yes, sir.
So do you mind filing those?
And boom, that's a classic no contact and no entry order. Judges love using these in theft cases to prevent repeat behavior. But here's the twist. Violating this isn't just a slap on the wrist. It's an instant ticket back to jail. Do you think banning someone from every Best Buy is fair or too extreme?
Conditions, no contact with the co-defendant, no going to any Best Buy, anywhere. And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond condition. We'll have you sign it. And after that, you'll be free to go. Okay?
Yes, sir.
Thanks.
Judge, I have two bond violations.
Okay.
The first one is Torres Noe. His bond violation is for failing to show up to a random UA. I tried reaching out to him, Judge. Apparently, he got deported. So that kind of explains why he's.
Sure about that? How do you know?
That's what the family told my office.
Got it. Okay, I'm gonna end up revoking it then, because
Yes.
I can't just leave it open. I'll leave it at 2501.
Yes, Judge.
Okay.
And then we reinstated if he's that.
I mean, let's see, like, more than likely, like, if it's not his fault, they just up and took him, then, you know,
Yeah, his family says he was detained by ICE and deported.
just I would reach out to the family, let them know, hey, if you're gonna get him back, do it the right way. You know,
Yeah.
like, get permission first, and then if I see that they do that, then of course, absolutely, I would reinstate it, so,
Sure.
who's second?
And then, Judge, the second one is gonna be Lambert, John.
With an L.
Yes, Judge.
Come up, Ms. Lemberg.
And Judge, I spoke with Mr. Lambert. He had a BAC of .03 on his interlock. I spoke with him about the incident. We talked about, let's just be honest about this and let you address it. We are asking for an admonishment because it is his first bond violation. He said he went out with friends on Friday.
This moment right here is the emotional peak. The judge basically tells him he either doesn't respect the court or he has a serious alcohol problem. This is where consequences shift from warnings to full-on surveillance. SCRAM monitors, GPS, curfews, the works. Imagine being monitored literally 24/7. Would that wake someone up or push them further off track?
Had some to drink. He didn't drive that night, but the following day he didn't know that he was going to be positive when he tried starting the car, and of course the ignition interlock picked on it. I did admonish him that your bond conditions are no drugs, no alcohol whatsoever. It's not only when you're driving, but throughout the pendency of the case. He understands that now. He is just asking if you would give him an opportunity change.
You had a DWI 2 years ago. Now you've got another one. We tell you not to consume alcohol, yet it's happening anyways. So either you don't care about court orders or you have a problem.
Yes, Judge.
Have you seen how many people we put in custody?
Yes.
I'm now going to put a monitor on your ankle so I know that you're not consuming at all. I'm going to put a SCRAM monitor that detects alcohol through your perspiration 24 hours a day, 7 days a week. I don't give a rat's behind what your next excuse is. If I find that you ever test positive for anything else again, I will lock you up. No more PR bonds. Do you understand?
Yes, Your Honor.
Your other ankle, I'm now going to put a GPS monitor and I'm going to give you a curfew of 9 p.m. to 6 a.m. If I find that you're out because I don't want you out in the middle of the night, likewise, you will go into custody. Do you understand?
Yes, Your Honor.
It is absolute no tolerance here for it. I don't care what your excuse is from now on. No means no. Do you understand?
Sir.
Okay?
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
Good morning, Mr. Villasana.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 7th, 2025, at approximately 7 p.m., officers were dispatched to a person in town on the West Digital Road in Harris County, Texas. The officers spoke with the witness, who the witness stated that the defendant was parked when he got to the location and was asleep in his motor vehicle. The vehicle was turned on with all doors were off. The witness stated that he knocked on the window multiple times to see if the defendant wakes up, that the defendant did not respond to knocking, and that the witness had to use a special tool to open the door and was only able to get the defendant and seemed a little bit off. The witness stated that the defendant had told him that he had been drinking a few hours prior to driving to the gas station, and that he observed a brisk man in the middle of the car, asked the defendant about it. The witness stated that the defendant had been in the hospital 3 days ago for alcohol problems. And another witness stated that multiple customers had stated that the defendant had been parked at the gas station, and when that gas station made accessible witness to the cameras and saw the defendant's car had been parked there since 6:30. The witness too went outside to check on the defendant, and the defendant was asleep and tried to wake up the defendant by knocking on the door, but he did not wake up. The motor vehicle was on. The officer observed a strong odor of an alcoholic beverage, poor balance, and disorientation. He refused SFSTs and admitted to consuming alcohol a few hours prior. An open container of Jim Beam bottle was locked in a hidden compartment of the passenger seat, and an empty can of Four Loko was located in the center console. A styrofoam cup with a lid and a cup holder with a liquid matching the color of the liquid in that Jim Beam bottle was also found. The DIC was read and the defendant refused breath. The blood warrant was signed and executed and was identified by his Texas driver's license.
Are you telling me that he had alcohol in the car while driving?
Yes, Your Honor.
Mr. Villasana, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever for any reason. Do you understand?
Yes, sir.
If I find that you do, I can have a contempt hearing. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you to obtain a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you have a problem with alcohol or illegal substances, you better address it. Because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am sending notice to DPS and I'm placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an interlock on it. I'm sending notice now to DPS in Austin so that every police officer in this state knows that if you're caught driving a vehicle and that vehicle doesn't have an interlock, they will take you to jail. Because I'm ordering you not to drive now, that's why I'm giving you a portable device. But do not drive. Do you understand?
Yes, sir.
You get no more warnings. If I find that you do, I'm going to lose it. Do you have the ability to hire a lawyer, sir?
Sir.
Okay, we will give you time to go hire a lawyer. I'm going to have you swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a receipt. You will get with Felicia your bond conditions. After that, you're free to go. Be careful, Mr. Villasana.
Sure.
Okay? You are Alejandro Castillo.
Yes,
Mr. Castillo, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, One will be appointed to you, sir.
Aún.
On March 6, 2025,
2025,
at 9 a.m.
9 de la mañana,
Officers were dispatched
oficiales
to a batch at a
fue
location in
localizado
County,
en
Texas.
el condado de Las Vegas.
Upon arrival,
Al
the officer
llegar,
met
los
the
oficiales se
complainant.
situó el quejante.
The complainant stated that she was sitting at a red
Estaba
light
en
and she
el
was
rojo
struck
cuando
by the defendant, and then the defendant
el
left the
demandado
scene.
huyó de la zona.
The complainant was
El
able to
quejante
get the
pudo
vehicle's
ver
license plate.
y tener la licencia.
The complainant
La placa
followed
de
the defendant through a
y lo
residential
siguió
neighborhood
a la
where the
vecindad
defendant lost
residencial
control of the
donde perdió
vehicle and
control de
crashed
la
into a
vehículo
house
y
about a
él
mile from
se
the
estrelló
original
con la
crash.
casa
The
en la zona del
complainant
quejante.
estimated damage to be around
Tenemos
$2,500.
resolviendo.
It is not under our policy.
That's what I was gonna ask you. Okay. Mr. Castillo,
Señor Castillo, muy bien, pues.
I'm going to find that there's sufficient probable cause to go forward with the case. I don't know what your immigration status is, but if you're not in this country with permission
Permiso.
and you go to jail,
Claro.
and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you, and you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here, so you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive.
No.
You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
¿Ocupar su propio abogado? ¿Usted puede ocupar su propio abogado, sí o no? No. No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
Was that a financial affidavit?
Yeah.
Venta.